Now, here's something interesting. We are only allowed to use this doctrine, this theory, and not bring in an expert under two conditions. The two conditions are that the patient did not cause or contribute to their own injuries. Very interesting. And we find that this really only applies in cases where the patient is under anesthesia having a surgical procedure. Okay? Because that's really the only time we can argue the patient did not cause or contribute to their own injuries. The second thing, the second criteria we have to look at is, would this negligence, would this carelessness have occurred but for the negligence of the doctor or the hospital staff? If we can answer that affirmatively, then yes, we can now use res ipsa loquitur. So, but for the doctor's negligence or the nursing staff negligence in the hospital, this patient would not have had a third-degree burn to his shoulder. Okay? That's obvious. But here's something interesting. Even though we don't have to bring in a medical expert, we're not required to, and I can go to a jury in that case without an expert, there are many instances where I will actually bring in a medical expert anyway. Now just ask yourself that question. I don't have to bring in an expert. I don't have to pay thousands and thousands of dollars to an expert to come in to talk to the jury. Why would I, under what circumstance would I still want an expert to come in and talk to the jury? Ask yourself that. The reason why I might want them to come in is because now I want the doctor to go ahead and explain. Tell the jury why it's improper. Tell the jury what the procedure is in the operating room of what's supposed to happen. Explain to the jury. Let them have a better understanding. Now, you should know something. If I don't bring in a medical expert, okay, now the jury simply has to rely on the testimony of the patient and anyone else we may have questioned during the course of the lawsuit. And that basically goes out with a little thud. There's no big explosion, there's no big drama associated with this finding. Why? Because we make the argument, listen, this shouldn't have happened. And the jury says, yeah, you're right. Okay, let's go on the damages. Well, why not just admit it? Admit you screwed up and let's just have a trial on damages. That's a double-edged sword. Because now the jury doesn't get the benefit of that righteous indignation of how dare this nursing staff allow this to happen? How dare the doctor cause this to happen? Carelessly, negligently. So by allowing a doctor to come in and talk to the jury, they now get a better sense of what this really means for the patient and why these procedures were violated in the operating room. So again, that's something to keep in mind when talking to somebody to see whether or not they might have a valid basis for a case. They may have a case, and you may have to bring in an expert. But then again, if this happened in the operating room, they didn't cause or contribute to their own injuries, and now what happened? But for this doctor's negligence, this injury would not have happened. All right, so now let's talk about, we're going to talk about little white lies. A little white lie. Your client, during a deposition, is asked a very simple question. Mr. Jones, have you ever been convicted of a crime? And he immediately responds, no, of course not. And now the attorney continues on. You think nothing of it because you had no indication, knew nothing, and you forgot to ask the client the question about whether he had ever been convicted of a crime. And your client, the injured patient, in his immediate knee-jerk decision to answer that question, thought, this guy's never going to find out. He's never going to know. This happened so long ago, it doesn't matter. I'm just going to tell him no. Okay, what happens? You can sense the foreshadowing, right? You're now at trial. Now, your client is on the witness stand. He's being cross-examined by the defense. And now the defense attorney pulls out his conviction record and confronts your client with it. And what happens? Your client turns to jello and he's like, blah, blah, blah. All right? Judge, I ask the court to take judicial notice of this plaintiff, this injured patient's conviction record. It doesn't matter what he was convicted for. Okay? Could have been something minor. If only he said yes. Then you could have dealt with it and argued that that had nothing to do with the claims being made in this case. But for whatever reason, he chose to tell a little white lie. That little white lie can go on to destroy this client's case.